Hot stove conversations about baseball, history, football, and current events that may leave you saying there's more to consider. Now here's your host, Jack Moore.
Welcome to More to Consider. Today I have on Ilya Shapiro. This gentleman is a University of Chicago law graduate. He is an expert in the Constitution. He's worked with the Cato Institute. He's now with the Manhattan Institute. So we're going to talk about the Constitution, maybe some of the confusion that people have with it. We have sworn leaders in D.C. and throughout the several states that have probably to some degree bastardized it or just don't really know what's in it. I think there would be a legitimate argument. Sir, how are you today? Welcome to the show.
I'm doing all right. It's a Friday afternoon. About to this is what's standing between me and the weekend. But when you're talking about elected leaders ignoring the Constitution, I think the epitome of this was during the debate over Obamacare. Gosh, almost 15 years ago now, when Nancy Pelosi was asked, well, what about the constitutional concerns about the individual mandate, the requirement to buy health insurance? And she said, are you serious? Because, of course, the Constitution is the last refuge of the scoundrel that doesn't have any good political arguments to make. And we've come a long way.
Yeah, and you've probably seen a lot of the same clips. I remember here in the Commonwealth of Virginia, our U.S. Senator Warner was at some kind of town hall, I want to say 15 years ago, and somebody raised their hand and say, what's the constitutionality of that? And he goes, dude, nothing we do is constitutional. Like, put that away. And I used to do talk radio in Norfolk, Virginia, and we had a particular, also U.S. Senator from the Commonwealth of Virginia that I won't mention. And he comes on the air with this friend of mine that's very libertarian, Vietnam veteran, Marine. And he's like, hey, I love the kids. Did I ever tell you how much I love the kids? And we're doing great things in Washington for education because generally we love the kids. We go to a break. My friend says, where in that their Constitution do you see education? And he laughed and said, if we follow the Constitution, we never get anything done. So there is some of that attitude. So I know we can kind of get into where it all went wrong. Now, you grew up in the Soviet Union, or you were born there, came through Canada and then on to the U.S. Go ahead, tell that story real quick.
Yeah, no, I was 4 when we left. My parents didn't want me growing up under communism, and this is the late 70s, early 80s, and Brezhnev was letting out Jews to go to Israel. We never ended up going to Israel. We waited in Italy in refugee housing for a Western country to take us, and Canada finally did. So I grew up in and around Toronto, and then enjoyed immigrating so much, had to do it again. And really, I was a precocious kid, and I decided fairly early on that I preferred life, liberty, and pursuit of happiness to peace, order, and good government, which is Canada's equivalent. And so finally made it down here, but it's hard. It took me a long time to get a green card. And then eventually I naturalized 11 years ago. And like most immigrants, I do a job that most native-born Americans won't, and that's defending the Constitution.
God bless you, brother. That's absolutely true. And I mean, I'm so happy that you're here and that you made this journey into this country. And that brings up a very interesting point or question is, as a young person leaving the Soviet Union at the age of 4, prior to the fall of the Soviet Union, you probably know a little bit about what you're living under. You probably learn a lot more as you make it out of the country and into other parts of the world. But are you, as a young man, fascinated by this ideal that you would think is promoted by the United States and its founding? Like, from your standpoint, what are you thinking of the United States? What are you thinking about the form of government as a kid?
Yeah, no, like I said, I was precocious, and luckily I was big for my age and into sports, so I wasn't getting beat up. But I was, reading a lot, and I think I read the Constitution for the first time when I was like 10 years old, something like that. Not a lot of it made sense, but kind of learning more and more about history and about institutions and what is the rule of law. My parents talked to me about how bad communism was and arbitrary rule and things like this. That's what really stoked my path to law school and to what I'm doing now. But it's the idea that, the division of powers, both horizontally in terms of the branches of government, legislative, executive, judicial, and vertically in terms of federalism. I mean, that kind of basic Madisonian theory, American Politics 101, Schoolhouse Rock, whatever you want to call it, that fascinated me and it captured my imagination. And I thought that's, that framer's conception of the checks and balances, of the division of sovereignty, all of those sorts of things. I didn't quite have the same vocabulary, of course, when I was 10 versus, 14, 18, what have you. But that led me on a path to believing that, there's a reason why America is the place where everyone, including myself, wanted to go for economic opportunity and to kind of realize that American dream.
Now, are you shocked, having come from the background? And again, you're a man growing up. You're growing into adulthood as you're learning, probably a little bit, maybe to some degree of shock to you, that it's not maybe what you thought as far as the very acceptance within this country of the founding documents and the founding principles. Are you shocked by that? I mean, are you getting here and going like, man, I'm reading these great works of men like Madison, as you mentioned, and it seems like the people in the United States don't even get it. Did you have a feeling of that early on?
Well, I didn't have a sense of what the people of the United States thought, but it did seem to me that the federal government seemed bigger and more powerful than what the Constitution allowed. And, again, growing up in Canada, we thought of Canada having a strong central government and the U.S. having much more federalism. But as I grew up, and especially by the time I got to law school, I realized that, over the course of decades, this is not an overnight thing. It's not a modern phenomenon. We've kind of gone away from that, and people look to Washington to solve all their problems. And that's why we have this dysfunctional politics, I think, because so much power has been centralized in Washington to the point now that I think Canada probably has more federalism than the United States.
Wow.
Because they had a separate history with Quebec driving that push for more provincial autonomy and all that. And even though, for example, Canada has universal health care, but each province runs that state-run health care. There are some ironies there. So as we've kind of gone away from or accreted power into Washington, and then within Washington, the shift of power, Congress doesn't legislate so much anymore. They kind of at best pass general things, and then the bureaucracy, the executive branch, writes the rules and regulations by which we live our lives. That's a warping of how it's supposed to be done. And that, by the way, is also why the Supreme Court every June, we just concluded, just a month ago, decides half a dozen of the major political controversies in the country. That's not the way it was supposed to be done. But because we have this massive centralization, and then within the central government, a skew towards the executive branch, that's what eventually throws everything into the courts.
All right, let's ask this question because, I'm an attorney, but
by the way, more of that dynamic I described in my previous book. Okay. I had one just come out earlier this year called Lawless, the Miseducation of America's Elites. But 5 years ago, I had a book called Supreme Disorder, Judicial Nominations and the Politics of America's Highest Court. And that talks about how this warping is why we have all these protests in front of the Supreme Court instead of across the street at Congress, where we should be hashing out our differences.
Okay. So I'm a college baseball coach. I went back into teaching and coaching and left the practice of law. And now I'm kind of dabbling back in law, but whatever. But when I was teaching criminal justice at a community college level, I'd always start the class off with, by what authority? And the kid's like, what are you talking about? And I'm like, first questions you should ask when you're talking about law, like somebody pulling you over in the middle of the night, potentially having something to do with your civil liberties, you kind of ought to know what probably the rules are, the jurisdictions. What does all this stuff mean? What does the Fourth Amendment stop mean? What does probable cause mean? So we get into these different things. So I would break out the Declaration of Independence. And they would be publicly educated kids were shocked to hear what was in it. I mean, they're like, Jefferson said that? I've never heard this before. So they were never taught that. So I would get into, and I'm kind of from that, when Jefferson directly borrowing from Locke, life, liberty, pursuit of happiness, property, that would be the
How could they not be taught that? What were they taught in their history classes? Just slavery all the time?
Probably most of that. And I'm not lying. They're kind of like shocked and pleasantly surprised to know what's in there. So I'd ask the question, who is this written to? One may raise their hand and go, King George III. I said, in part, but really to the world. Jefferson's like, hey, we're having to justify what we're getting ready to do. And in that document, he said, when government fails to meet these ends, then you have the duty to alter or abolish. It's a revolutionary document, etc. And I bring up that point to say now the battle begins. When you read the Federalist Papers, Hamilton and Jefferson are certainly no fans of each other. Hamilton, of course, loses his life over choosing Jefferson over Burr, but it's contentious. And you go back and look, you think things are bad today, and I know you know the history. When people think things are bad today in the press, hell, the stuff they wrote about each other, 250 years ago was amazing.
Somebody took the pamphlets that were used in the Jefferson-Adams election in 1800 and made them into kind of modern style campaign ads. It's really something. It's hilarious because, yeah, the language they use is worse than, Trump Clinton or Trump Biden or whatever. Yeah.
And when this seemed like a big Sally Hemings and the whole, whatever happened, well, I think we know the history, but that came out at the time. They were writing articles of Jefferson and his it really wasn't an extramarital affair, I think, at that point, because his wife had passed. But anyway, they're writing things about their personal history. And I always bring, and I just want to get your take on this, I always get into the question of the hatred of John Marshall to Jefferson. I believe they're not too distant levels of their cousins, basically. And I think they're about 12 years apart. And
they're both Virginia gentility, yes.
Oh, absolutely, yes. Marshall is a Federalist, and now on Adams going out, there is the famous Marbury gets his appointment, which isn't delivered because Marshall's moving his stuff down the hallway from being Secretary of State to being the Chief Justice of the Supreme Court. It doesn't get done. So then he goes after Madison, the new Secretary of State. Jefferson's like, ignore it. But you have this Federal Judiciary Act of 1789, which apparently allows for the writ of mandamus to be issued. And Marshall famously says, Mr. Marbury, you're barking up the right tree. Nice try. But this act of Congress to expand the jurisdiction of the federal courts is unconstitutional. So, boom, we have judicial review. And what that has done,
and by the way, that was a fight over court packing and changing the judiciary for political reasons. Court packing didn't start with, the modern era or even with FDR.
Not with FDR.
It was right back at the beginning. And for that matter, you think about political battles over Supreme Court nominations. George Washington, of course, our first president, had a nominee rejected for the Supreme Court for political reasons by the Senate. So there is very little new under the sun.
Well, and Salmon P. Chase was impeached.
He was impeached and not removed by one vote.
Yeah.
Yes.
Yeah. So again, so we could say the way the framers put it together with some levels of kind of this regulation of the contentiousness of it, it was working. But I want to ask your take. Do you think the Marbury versus Madison, they got it right? That the Supreme Court has the authority to say what the law is? Because it was an act of Congress. So it's an act of Congress. And now the Supreme Court is standing in to say, we take this power. So he gets his jabs in at Jefferson, who he can't stand. But Marbury still doesn't get his appointment as
it was a Justice of the Peace.
Justice of the Peace in the District of Columbia, right? So he doesn't get his appointment. But now Marshall takes in this big chunk of power. So what do you think about that? Do you think they got it right, or is there something else there?
No, I mean, judicial review is implicit in the constitutional structure. The Constitution is the highest law of the land. Congress can't just pass willy-nilly legislation in ignorance of the Constitution. The courts are there to review those kinds of acts, and arguably in the early days, that's most of what they can be doing. When somebody sues somebody else or somebody's being prosecuted, all that is done in state courts. There's very little federal law to adjudicate for the Supreme Court. So most of what it was doing were such questions as, one state taxing another state's residents, is that constitutional? Tariff barriers between states, the Bank of the United States, right?
Right. Oh, yeah.
Coming up. So all of these, and then obviously eventually slavery and fugitive slaves and things like that. But there were these meaty federal issues of delineation of power, these constitutional issues. So absolutely, judicial review of what Congress does is part and parcel of the court's remit. And I think it wasn't specified in Article 3, which talks about the court, just because it was just such a background understanding. Kind of like we have the Fifth Amendment, the takings clause. You can't have a taking of private property for public use without just compensation. It didn't, before saying that, there's no provision that says the federal government has the power of eminent domain. It's just one of these background principles of sovereignty.
Yeah, and I think, if I'm not mistaken, Article 3 is pretty just like Congress shall make whatever, there'll be a Supreme Court, and they hadn't named a number, and then whatever inferior courts from time to time that Congress shall so ordain. I mean, that's kind of the
Congress
language.
Today, tomorrow, can get rid of all the lower courts if it wanted to. Absolutely.
So I'm not sure I'm totally straight on why they didn't have the authority to expand this jurisdiction of the courts, but okay, that's the view Marshall took. Go
They
ahead.
did. It was a question of, did they have the power to require the delivery of the Judicial Commission. The expanded, the added judgeships were valid, but they didn't have the power to force the delivery of the commission. And eventually there was another Judiciary Act that got rid of a lot of the judgeships that Adams and the Federalists added during that lame duck before Jefferson came to power. And eventually Jefferson tried to do the same thing. He added seats to the Supreme Court. Of course, the country was growing, and as they added new circuits, they added new justices to the court. But he failed in his appointments to the court. His nominees ended up falling under the sway of the great chief, John Marshall, anyway. So, people have, again, presidents have tried to influence the way that the Supreme Court has gone from time immemorial.
Now, Jefferson did argue, did he not, that why would the executive branch or some member of Congress or anyone else not just as much have a take on what's constitutional as, and I believe at the time it was 7 members and not until the mid 19th century did it go to 9. Is that right? I think it was.
Right. It's fluctuated from 6. And at one point there were 10 seats authorized, although the 10th seat was never filled until by statute, this is not in the Constitution, by statute in 1869, it was fixed at 9. It used to be, as the country was expanding, they would add circuit courts of appeal, and each circuit, they had the same number of justices. And they stopped doing that once we got past a certain number. Now there's 11 geographical circuits plus another, 12 geographical circuits plus the federal circuit. But anyway, where were we going with this?
Well, we're talking about, like Jefferson said, every other branch or members of other branches can just as much have a belief what the Constitution is.
And they have a duty to interpret the Constitution for themselves. When you're voting on something as a congressman, you're supposed to think about whether it's constitutional. Now they don't, of course, but that was part of the duty, and what the president was doing as well. This was crystallized perhaps under Lincoln. This is a theory known as departmentalism. Each department, each branch thinks about the Constitution for itself. And if the president disagrees with the Supreme Court, he can't ignore its orders, but he can treat them as limited to the parties before it, to the situation before it. So these kind of debates that we're having about the propriety of broader injunctions and who are the parties that are actually bound and class actions and things, that has resonance with things that were going on 150, 200 years ago.
All right, so there is the Bill of Rights. I've actually been in the National Archives and seen some of the handwritten notes of the original proposed amendments, and I think they whittled it down from 100 down to about 12. And one of the original 12 was ratified 202 years later, and that was the one whether Congress could vote themselves a greater increase in salary. They had to go through another election cycle. And I think it was actually 1 and 2 were the ones in front of the 10 that actually made it. So it was 3 through 12 that actually made it. But we had the Bill of Rights. Then there's a quiet time, pretty much. And then you have this about 80-year period, American Civil War. So you get 13, 14, 15. Then it's pretty much a quiet time. Then you get to the early 20th century. And then you start to have the 16th, 17th, 18th, 19th, these amendments come about. I bring up
Progressive era, yeah.
Progressive era, exactly. So there have been some, it's some political realignment, but it's definitely a restructuring of the country. So we have this revolution, we have the Civil War, and then the post-Civil War, we have these amendments.
What's known as the second founding sometime, because it changed the relationship of the citizen to the state to the federal government. For the first time, you were able to go to federal court and claim that the state was violating your constitutional rights. You couldn't do that before. The Constitution only applied to the federal government. Constitutional rights only apply to the federal government. Yeah, so that was a restructuring. And to this day, we're debating the meaning of the 14th Amendment, what rights those are, and how exactly they're protected. I think you might have been getting to this. So, then there was another slew of amendments in the progressive era, as you said: taxation, women voting, prohibition, then no prohibition.
Senators being elected by the
direct election of senators.
Yep.
In the New Deal era under FDR, there effectively became a constitutional amendment with the expansion of federal power to deal with the Great Depression and otherwise. But the political leaders at the time, even though the Democrats had supermajorities in both houses, Roosevelt was reelected in a landslide, they chose not to pursue constitutional amendments. So in effect, they changed our constitutional settlement without going through the amendment process. And I think it's from that period that we think of constitutional amendments. Well, we shouldn't bother with that. That's just with, we only do that to end slavery or give women the right to vote. Nothing nothing else, only these world historical things. And so that's why I think where it began about 100 years ago, people beginning to think that, we can, in effect, modernize the Constitution without needing to amend it.
All right. So one thing, I'm much older than you are, so I've been watching this thing a little bit longer, and I kind of listen to pop culture or what's out there in America, sort of the language. And when I see the alphabet networks, the alphabet, you know what I'm talking about, and they are always, you've seen these montages, I'm sure, on YouTube, where they're literally saying the same thing, just one talking head after the next. And I started noticing, however long ago, 25, 30 years ago, well, the first one I remember was gender. I kept hearing gender all the time. I'm like, people are talking about sex. They're talking about male, female. They're not talking about, and what the hell is this gradation of masculine to feminine? And then the next thing you know, we see the language change. And then the other one is, it's an attack on our democracy, our sacred democracy. I'm like, where the hell did they get from democracy? Like, that's not in the Constitution. And I had a law professor that made the point, I think it's a valid one. The only aspect of democracy they wanted in the federal structure was you voted for your member of the House, and you could vote for the dumbest ass farmer down the street if you wanted to. And then the state would select the U.S. senators to go protect the state from Washington. So if we were in Richmond, where I'm in Virginia, the governor or whoever the state legislature selected is there to go to protect. So you could have all the craziness in the House you could want on some kind of proposed bill to spend money, do whatever. And the Senate would be the check against that. And then the progressive era.
The cooling saucer, as Jefferson put it. Yeah.
Yeah. And then once you put two more whores in Washington, because they're going to be elected by the people, you've upset that aspect of the setup. And they never intended for people to vote for president. Clearly in Article 2, it says the electors would select, or the state legislatures would select the electors. And I did a little bit of research in this, and 11 states voted in the first election because 2 had not yet ratified the Constitution. And I believe 6 allowed the people to vote and 5 did not. And I don't think South Carolina allowed people to vote until the 8th. So clearly, and so the view was once they decided to let the people vote to be the mechanism to select the electors, knock yourself out. But this idea of the people, the common man voting for president was not something they really intended or probably were very comfortable with. I say all that to say, you know this, if you go down the street now and you go up to your M1A1 guy on the street, do we live in a democracy? Damn right we live in a democracy. Of course we live in a democracy. And I think this has been some of the slide towards the top-down government from the federal government down. Fair? What do you think?
Yes and no. I mean, there's been kind of a democratization of modern countries anyway. And you talk about the direct election of senators. By the time the 17th Amendment was enacted, about half the states had the direct election of senators anyway. Right. And the others were trending that way. That's why that was ratified. The states wouldn't have ratified that if the writing wasn't on the wall already. So a lot of people say that, if we just got rid of the 17th Amendment, that would help governance a lot. I don't think so. I mean, things were going that way as well. Same thing with expanding the franchise, first to men who didn't have a lot of property, then to black men, then to women. That was going to happen, just the way that the polity developed. The issues, I think, are less about this, whether we have direct democracy or not, but about the checks and balances and respecting the powers and not poo-pooing these constitutional limits. Whether it's the federal involvement in education, the federal over-criminalization of things. You can. There's one case from about 15 years ago where a guy knocked off a pizza shop in suburban Cleveland, Ohio, and he was brought up on federal charges. Like, why would you rob a pizza shop? Why is that a federal crime? Well, it's an interference with interstate commerce.
God, that's amazing.
The tomato sauce, the cheese, and the flour came from interstate. I mean, come on.
That's crazy you say that, because when I was in law school, I had a friend interning in the Norfolk, Virginia, in the U.S. Attorney's office there, and she's going through some files, and there was literally a robbery of a Pizza Hut. It was a Pizza Hut. And she said to a guy in there, like, what the hell is that? And he goes, it's like, it was a Smith Act, or, the something that said, if you rob an establishment, you interrupt, the sausage coming from one place and the cheese came from Wisconsin. And She's like, are you serious? Well, we won't touch it. Virginia Beach will prosecute it. But if we wanted to play Fed with it, we could. And she was shocked. Like, really? It's a federal crime? Yeah, only because of the interstate commerce thing, which is used, as you know, it's the link to everything they do. And, well, let me ask you this, too, because I wrote my master's thesis on the Kennedy assassination. I weave that into every discussion. But I watched thousands of hours of the coverage of it.
I have a bunch of those books. When I was about 14, 15 is when Oliver Stone's JFK movie came out. So I started reading all those books. Yeah. Anyway,
Oswald did it, by the way. Anyway, Oswald did it, but I remember being fascinated that on the morning after, Hugh Downs, and this is way ahead of your time, but Hugh Downs, he had a career in television for years.
Now, I remember him with Barbara Walters on 2020.
Yes. Yeah. Well, she's actually on here, too, as a younger woman. Well, a much younger woman. The next morning, they're doing like Good Morning America type, whatever the level of show was at the time. And he has a constitutional legal expert on there, and he's saying, because Oswald's not yet dead, this is the next morning. And he said, well, Oswald will be charged with the state crime of murder within the state of Texas, blah, blah, blah. Kennedy's dead, but Oswald's not yet dead. And Hugh Downs says, like, you mean to tell me this isn't a federal crime? He goes, no, it's not a federal crime to kill the president. Now, there is some talk about the legislature getting together in Congress, and then they do. I think it's 65, they passed the law to make it. Now, Lincoln's killed in Washington, Garfield's killed in Washington, and McKinley's killed in Buffalo, New York, and that guy gets executed under state law. So unless there had been a conspiracy crossing state lines, law would have been, and that seems shocking to people. Some might say that was a stretch to make it a federal crime, but I also think there was a practicality in the protection of the president.
No, I have no problem with Congress criminalizing the, killing federal officials, president or otherwise. I mean, that's not one that keeps me up at night,
Right. But I mean, it is kind of a stretch, though, I think, from the foundation of the country, from the action, the general police powers and whether or not the federal government. But again, you can see
the bigger stretch is the pizza shop robber, or just generally regulating the pizza shops.
Yes.
To have them comply with OSHA, federal occupational health and safety regulations, to have them comply with, have the state health inspector in there, have the state labor department, absolutely. But to have the feds involved regulating what they're doing, even if it's part of the Pizza Hut network. I mean, fine, regulate corporate Pizza Hut practice or what have you, but each local shop, that should be for state regulators to handle.
All right, and doing some prep for watching you and kind of getting into your background, I watched you on a few shows, and this is a bombshell subject generally. I mean, I think it's something that's a hot potato. What about speech and campaign financing? Like the whole idea about money in politics and who gets to say what, and where does the federal government, or does the federal government really have a legitimate authority or jurisdiction to regulate this? What do you think about all that?
Well, the government has authority to regulate lots of things that has federal implications, crosses state lines, as we were just discussing, but it can't regulate speech. So that's where the problem comes in. And it's not the issue that, people say, oh, but money isn't speech. Well, yeah, but neither is printing presses, neither is laptops, neither is the internet, neither is, megaphones and newspapers. But censoring newspapers is clearly a First Amendment violation. So similarly, spending money that you're spending on censoring money, restricting money that you're spending on getting your political message out is a regulation of speech. And it's a fairly novel thing for the government to be involved in regulating campaign finance. I mean, Dwight Eisenhower famously ran for president only after 5 big industrialists met with him in a hotel room and said, look, don't worry about fundraising. We know you don't want to do that, but you're the man for the time. We'll handle the money. You'll have all you need. And that's the way that went. And in these modern campaign finance regimes is what has forced politicians to spend so much time fundraising, because they have to raise their money in very small increments. So they have to dial for dollars all the time, including presidential candidates. So then you have the rise of these independent, whether it's PACs, whether it's other independent groups. And then you have this imbalance where independent groups can raise money and spend it however they want, which Citizens United ratified, 15 years ago, but candidates are still restricted and parties are still restricted. And so you have this kind of imbalance. I think, we've been chipping away at the modern campaign finance regime. The Supreme Court has. It's going to continue doing that. There's a case next term that they just took up about rules blocking coordination of spending and messaging by parties and candidates, which seems idiotic. Why shouldn't a party and a candidate be able to coordinate their message to get elected, right? So I think this is the modern campaign finance regime is one of the reforms post Watergate to try to get rid of the appearance of corruption. But I think in most ways, it kind of threw the baby out with the bathwater and created these weird regimes that benefits nobody other than accountants and campaign finance lawyers who have to wade through all these obscure regulations.
So, kind of back to the schoolyard. We're at the playground talking about the things.
Just to put a finer line under it, I think the best solution would be to remove all these different restrictions and have instant disclosure. You want to take $1 million from that guy, from that guy, from that guy, that's fine. Just disclose it and then, then speak.
Well, so the part I'd throw out in response to all of that, and I'm on board with you, if someone's going to argue that there's all this ugliness as to money influence in how it plays out in elections, then one would think they would see some correlation with a lot of money spent, bought the election, won the election. And I think in this last one, I don't know exactly what the Harris campaign
the last several cycles indeed has also put pay to that. I mean, and not just Harris, but Hillary Clinton raised and spent more than Trump in 2016. I forget what the numbers were in 2020, but yes, past a certain threshold of viability, each given race, Senate, Congress, president, whatever, there's a given threshold to be viable. Beyond that, it's a waste.
So I guess the question would be too, is there ever a point, like I mistrust or distrust all of this. There's never been a time when I have in the ancient days had a radio on, now whatever the YouTube is on or whatever television, whatever means of entertainment or whatever I'm listening to, I don't hear a message from someone that's batshit crazy in a particular political field. Like, well, hell, now that they've said it this way, and I bet that was sponsored by somebody, I'm changing my mind. I'm going to vote for this. I'm not. It's not going to change what I'm thinking. I don't care how much money they spend. Now, I don't know what percentage of people are kind of locked into that kind of mindset. I mean, I think that we've kind of seen the last few election cycles. There's kind of 30% this, 30% that, and then there's some 40% in between that fluctuates to some degree. There's a hard 10 on each side. So that's kind of where the American people are. So what do you think is really driving those who are attacking this mixture of money and message? It just they want to shut down certain types of speech? Is that all it is, really?
I mean, you don't even hear about it that much. I think because Harris raised and spent so much more than Trump. Like, I'm not hearing a message from the who 10 or 15 or 20 years ago, the kind of small p progressive good government type quote reformers were all about campaign finance. Now you don't hear that so much. I mean, you hear it a little bit in terms of special interests, or Sheldon Whitehouse has a burr in his saddle about who funds amicus briefs, an issue near and dear to my heart because I file a lot of them. But, I think they're projecting. I think, they get money. They listen more to their donors, I guess, and they expect donors to be buying institutions. I mean, the causation arrow goes the other way. I can tell you from a long history of working at different think tanks and working with advocacy groups, the donors find you if they like your message. It's not that, you're a hired gun that changes them. I don't sit by the phone every day saying, what's our chairman of our board of trustees? What's he going to tell me to do this week? No, it's like, if this is our organizational mission, and we'll find people who support that mission, and they'll find that. And that's hard to believe, but that's the dynamic in, whether you're left or right.
So with Manhattan Institute, formerly Cato Institute, I mean, certainly with Cato Institute, my knowledge has always been, sort of libertarian leaning type of think tank. And
MI
Yeah.
is kind of broadly center right. We have lots of
Yeah.
different kinds of people. And what distinguishes MI is that from its founding nearly 50 years ago now, it's been the center right think tank that focuses on cities and urban issues, because after all, most Americans live in
Hmm.
cities. And so you get a lot more on policing and housing and education and healthcare and these sorts of things. Now, that's not what I was hired to do. I was hired to speak to the courts and deal with national constitutional issues while interfacing with my colleagues who work on all these different things. But that's always been Manhattan Institute's MO, and being based in New York rather than DC, more sensitive to financial regulations and other things. It's an interesting and very dynamic place.
So I throw this out in a lot of shows, kind of like the deeper level, like the philosophy of where you come from. So what was really impactful for me several decades ago was Finding the Law by Bastiat. And that
Mm.
just really struck me.
Mm-hmm.
Here's a
Mm-hmm.
guy who's dying of tuberculosis. He's fighting against socialism at the same time as the Communist Manifesto. And he opens with the law perverted. And he basically says that when the government begins to work in certain areas and it begins to create plunder, and he said that's the government's use to pad the pockets of whoever for whatever political spoils, there's only one of two things you can do: become a part of it, be political, or end it. And I'm reading what he's saying, and he's saying that the only thing that legitimately can be done by government is what you can do, and that's your right to self-defense. It's the right to self-defense collectively. So as I used to teach my college students, you're walking down the street, somebody hits you over the head, takes your wallet, they've affected your life, they've affected your property. So if government has a righteous role, it would be to make you somewhat whole, punish the wrongdoer, return your wallet, make him pay restitution, whatever. But feed, clothe, educate, all these other things becomes pretty squishy. And it's always going to be some aspect of someone's religion, beliefs that's going to dictate these things. And then it becomes a question of, is that really the function of government? So my friend I used to do the shows with, he used to ask politicians that all the time. What is the function of government? And believe me, unless they were libertarian, they never were ready for that. Because the libertarians would say something like, protect individual rights, life, property, force, and fraud from others. Boom, go on to the next thing. Some of the answers you get would be all over the map. I think we ought to have a program for this, a program to open up the sky, a program to make us feel better in the morning. And you'd hear all this, and I'm like, really, where do people come up with that? Why do they think that's a function of government? So I say all that to say, where is your greatest frustration in what government does, and where you think it's out there on the extreme somewhere and needs to be reined in? Where is that for you?
So two things. On the right side, people think that anything that is important or what they want people to have, they couch it in the term of there's a right to that, or there should be a right to that, whether it's healthcare or housing
Yes.
or food or what have you. And that is what philosophers call a category error. Your
Mm-hmm.
rights are what you're born with. Something
Mm-hmm.
that you depend on someone else to provide. It could be very important. We might need a program for it or not. We can debate that, but that's not a right. A right is something that the government can protect. We pool our sovereignty to form a government to secure and protect those rights, but it's not something that you can demand from someone else. So that's number one frustration. Number two is on the power side. Whether you're talking at the federal level with, are you serious about the Constitution? If it's a problem, then government has to have the authority to act, and we'll figure out where in the Constitution that comes from later, if at best. At the state level, state constitutions don't always enumerate the powers that state governments have, because states are a different kind of sovereign. They pre-existed the Constitution. They have kind of background authority to legislate for the public health, safety, welfare, and morals, as
Mm-hmm.
traditionally is
The general
explained.
police power.
The general police power,
Mm-hmm.
exactly, which
doesn't exist in the federal Constitution.
which does not exist federally.
Yeah.
That's right. That's a government of enumerated and therefore limited
Yes.
powers. And
Amen.
the language again, it can be confusing, because it's not. I mean, the police, as we think of law enforcement officers, are part of that, but it's
Right.
not just police. It's
Right.
these police powers. Doesn't have anything to do with the band that Sting headed up in the 80s either.
That's right.
Although when I was writing blog posts and op-eds about Obamacare and regulating every breath you take, I made puns about the police power in that way. But those are the two things, kind of a misunderstanding of the rights, of what rights and powers are. For the federal government, that's encapsulated. It's kind of a cheat sheet, the 9th and 10th Amendment. The 9th Amendment says the rights, we've just listed 8 rights. We've had 8 amendments, but that's, to be clear, we have more rights than that. That's, the other rights are still retained. And on the other hand, the 10th Amendment says that only those powers that are listed, most notably Article 1, Section 8, that lists 17 powers that Congress has, plus those powers that are necessary and proper for executing the preceding powers, that's it. And that is finite. So powers and rights are work in different ways. And that is the basic understanding that you need to start to get people to start understanding what the Constitution's about.
All right, so I made a comment the other day on the show. God, I'm going to go way far afield here. I know it. I'm throwing a grenade in the room, but I'm just using for point of illustration. So I was talking with a friend the other day, and I've come to, in listening to just kind of pop culture arguments over the Second Amendment all my life, in doing some deep dive study in the last 2 decades, I'm more and more convinced, especially looking at Madison and being from Virginia, it's pretty much father of country, guy that wrote the Declaration, and guy pretty much wrote the Constitution. It all pretty much happened here, right? Virginia, we're pretty important on that. And I have my pictures of Secretariat up here, who was the greatest athlete to ever come out of Virginia. So I'm looking at it, and I really get the view, and I want to run this by you, that Madison was simply saying we don't want standing armies, and that the language of the Second Amendment might be somewhat confusing to people today. But you look at prior writings of Madison, he's very clear about this. And I look at Article 1, Section 8, and it says all these gyrations involved in raising armies in times of military need, never for more than 2 years so you can vote the bastards out to vote for an unpopular war. And the next sentence is provide for the Navy. That sounds like a standing Navy, right? And then when he needed to put ground forces out there to fight the Marbury pirates, he sent the Marine Corps. So the Marine Corps are clearly federal troops, in my view. They're not state militias. They're an aspect of the ground forces of the Navy, basically. So I'm looking at all that, and I make a point on a show recently where I say, but in no way does that mean that the states couldn't regulate the militias and regulate firearms. And this guy writes in the comments, well, the Supremacy Clause, federal, and I'm like, well, the Bill of Rights aren't law. It kind of says what the laws can or cannot be. Like when it says Congress shall make no law, it was saying you can't make laws as against people's free speech or religion or whatever. And I've done some history looking at, and it would seem a well-regulated militia being necessary for the security of a free state. They were saying, Virginia, knock yourself out, regulate your militias. When we call you in times of need, you set the officer corps.
Well,
yeah. So what do you think on that?
That effectively is how it worked. But what the Second Amendment meant was that prefatory clause, a well-regulated militia being necessary to a free state, was saying that, look, we just fought this revolution. We're suspicious of tyrants. We want a well-armed citizen. States can regulate their militias. Militia, by the way, was a term of art of all able-bodied men between the ages
of a certain age,
like 18 and 45 or something.
Right.
And they basically said that it's, that you can't infringe the right to bear arms because we need the militia, men of that age, to have access to firearms because we're so concerned about. But that was updated when the 14th Amendment was passed.
Well, that's where I was going to go next.
There were different concerns.
Yeah.
It was no longer King George or some other monarch tyrant that was being concerned. It was the dispossession, whether of freed slaves or Northern sympathizers in the South or other kind of unpopular minorities. And that's why the conception of the right to arms in the post-Civil War period as protected by the Due Process Clause and the Privileges or Immunities Clause of the 14th Amendment is a much more individual rights dimension than at the founding of the Constitution during the Second Amendment, when it was thought of, we have to give these individual rights to people in order that they can be an effective militia against tyrants.
Well, and a friend of mine made this point. He's got a friend of mine. He's a PhD from UVA, but in foreign affairs. He's a really bright guy. And he said to me one time, did you ever think about this sequence? Second Amendment, don't come around and take our weapons, because that's what the British did. Third Amendment, Quartering Act, stay the hell out of our house. A Fourth Amendment, don't come without a warrant based upon probable cause. So it kind of made sense that, and they're looking at people of the same race, ethnicity, religion. How the hell these new leaders won't do the same thing that the tyrants had done? I don't disagree with that. My only point in making that statement was, in Barron versus Baltimore addressed the issue of, does the Bill of Rights apply to the states? No, it does not. I'm saying post-14th Amendment, now it's not till the 20th century we get into the incorporation doctrine. And then that's a question, because I guess what I'm saying is I've never believed that the Second Amendment was about hunting Bambi or home protection. I think it's about the political right of having a firearm.
Yes.
And right. Now, what's interesting is, as you know, most all the states ripped up their constitutions, started over, or wrote new ones, or modified or amended. In Pennsylvania, if you read theirs, was you can hunt Bambi, you can have home protection. They said everything that you would like for the Second Amendment to have said about firearms. So when the Heller decision came out and subsequent decisions come out, and they're getting into this issue whether you have a right to home protection, I don't think that's what the Second Amendment is about. I don't have a problem with it. I'm kind of glad it came down that way. That, that they're saying, yeah, in effect, you can have a firearm in your home, et cetera. And then you get into the regulation of what types of firearms. But my only point on all that was, I just think that's one of those things that's been hidden out in the open forever, that what Madison was really addressing is they were scared to death that if a despot got a hold of a professional army, they wanted the soldiers to be the citizens, and they wanted them to come from the several states. My only point was, I think prior to the 14th Amendment, the states had every right to regulate the firearms, have arsenals, do whatever they want to, muster with the military or with the militia, regulate the militia. If they wanted to keep all the weapons at a local arsenal, I think they had every authority to do that as a state. That's all I was saying.
That's probably right. But again, the Second Amendment was against the federal government, and so
right. So so there wasn't any authority there. So what else bothers you there? What else do you think, if you could wave the magic wand right now?
Well, I was part of the National Constitution Center, which is a wonderful museum in Philadelphia. Everyone should go visit. I do programs with them every now and again, and they did a constitutional convention project. Mm-hmm. Basically dividing up teams, conservative, progressive, and libertarian. I was the captain of Team Libertarian. And, you could either start from scratch or you could just amend the existing Constitution. Mm-hmm. And we operated from the basic conceit that the Constitution is fundamentally a libertarian or classical liberal document, yes, the product of its time. And so all that was needed, the only amendment that was needed, was to add to every clause, and we mean it. Now, we did clean up a few other things that Madison failed to anticipate in various ways, but I think that's generally the case.
Okay. We're in closing. We've gone about 45 minutes to 50 minutes or so here, so I want to close out here. You've been a wonderful guest. What is really kind of the core of what you're fighting, right? If you're fighting anything, I don't know that you're fighting, if that's the term you would use, but what's really the battle right now here in 2025 with what we see happening in the country? Where do you think most of your efforts are directed at this point?
Well, I'm sort of involved in a culture war in which the Constitution certainly plays a part. But in my time at MI, it's been just over 3 years now, I've spent probably as much time on higher education policy as on constitutional law. I had this brief but significant and high-profile experience with Georgetown Law School, where they tried to cancel me over a tweet, and that got me into learning about the DEI structures, mm-hmm, and how higher ed has gone off the rails in various ways. And now, of course, we have the federal government trying to force institutions of higher education, notably Harvard, Columbia, kind of the so-called prestigious ones, back onto the straight and narrow, because it's going to take those kinds of exogenous shocks to fix them. But it's all part of the same thing. If we ignore the Constitution, if we think that government can do whatever you can just get a majority of people to vote for, at most, or whatever in some advanced postmodern theories of the Alinskyite model, you have your or the Leninist model for that matter, you have your vanguard that takes control of the levers of power, and away you go. But that's our education system, I think, is highly out of whack. That's higher ed. For K to 12. I think school choice is educational freedom is the civil rights issue of our time, and that's really important. But beyond that, I'm sort of taking a breather since my last book came out, which is about the perversion of legal education, especially, which is dangerous because, of course, lawyers are the gatekeepers of our legal and political institutions. But I'm just looking at what's coming out of society and trying to promote a constitutional vision that would allow every citizen to pursue his or her vision of the pursuit of happiness.
When you say that about higher education, I'll never forget. It had to be late 90s, I would guess. I have the whole gambit of the cable networks, and I have C-SPAN at the time. I'll never forget this young lady. She's a keynote speaker at some event. She's Pepperdine to Stanford Law School. So she's gone Pepperdine undergrad. She's 4.19 GPA. I mean, she's that girl. And she's going to Stanford. And she takes the LSAT. And so for those of you that know, it's kind of like the SAT for law school. And it's on a system where if you want to get into Harvard, Yale, whatever, you got a pretty score. You got to score at that, that 1 percentile. You got to be at the top of that test. So who puts together the test? American Bar Association, et cetera. And she does a deep dive study as like her senior thesis on the test. And what she said, I'll never forget, and I'm telling you now, it scared the hell out of me. So she said, like any type of standardized test, it's 5 questions that make the difference. It's on a bell curve, and most people are going to be right there in that dead center. And what swings you from this university to the top tier, you might get 5 more questions right. She literally read some of the questions, and it was frightening. It was like fact pattern, fact pattern, fact pattern, and A, government has no business doing that. B, well, government probably should regulate, but only under Congress. And then it was C, can't get enough government. Government's always the answer. That was the right answer. So her point was, how many libertarian types could be very bright, high IQ, very academically inclined? They take that test, and that test is skewed towards always a particular answer.
That sounds more like the bar exam than the LSAT. Because the LSAT, as I remember it, there was logic games, there was reading comprehension, and there was like.
But when did you take the LSAT?
That would have been 98.
Okay. Well, I mean, again, now she could have been lying. You always open up to I'm not saying the young lady was lying. I don't know who the hell she was. It's 25 plus years ago. But what she was doing was reading questions and the model answers to make the point that if you have a particular worldview, now you're getting a 160 instead of the 180, or you're not a 177 and going to Harvard or Yale. So what is the gatekeeper doing? Who ends up going to Harvard, Yale, whatever?
Well, I think the bigger issue there is the admissions offices that put a thumb on the scale for activists rather than those who say, oh, I want to be a prosecutor. I want to be a partner in antitrust to help consumers have lower prices or things like that. Especially,
it might be, but if that score is going to be skewed somewhat by a slant,
I'd want to read that.
Yeah.
In writing this last book, Lawless, I've read a lot about that, and I don't think the ABA has much involvement in the LSAT. They do in bar exams, they do in accreditation, and they're nefarious and all of those sorts of things. The LSAT may have a problem with it. The last few years, I think it's been dumbed down a little bit, so I think you have some compression of scores. But anyway, maybe I missed this, but that's not something that I think at least I came across as a major concern, as opposed to just if you write in your personal statement, in your essay, in your application, that something that comes across that you're not progressive, that might harm you. And again, that's going to the admissions office or the DEI office or something like that.
Yeah, and so where do you think DEI is now? Do you think it's going to flame out and die, or do you think it's going to have, there's going to be some level of resurrection with that? What do you think is going to happen?
Well, it's going to be different in different states because state legislatures in many states are abolishing their DEI structures in universities. Chris Rufo and I, 2.5 years ago, put out model legislation to that effect, getting rid of the bureaucracies, diversity statements, trainings, all of these different things. And that's to the good. The federal government is trying to do things like that as well, although I think a lot of these bureaucrats are going to try to wait it out and kind of be in a defensive crouch until the next Democratic administration, takes its foot off the gas of getting. So it's we're in the eye of the storm there. In society writ large, we seem to be past peak woke. And there's a lot more market-driven changes, and CEOs who are amoral. It's not that they're true believers, but they want to do something that's good for the bottom line, and they're happy to have an excuse to get rid of this office, these structures that are draining their profits. That's the dynamic in the rest of society. But higher ed is kind of insulated from these market forces, so it's gonna take some time to fix them. And some institutions, I think, will continue to decline. Although savvy university presidents will, see what the writing on the wall is and respond.
Why has there not been more of a groundswell to have competing colleges or universities to compete against what's happened the last half century or more?
Well, brand new ones, it's hard. It takes a lot of capital. You're starting from zero, not just, buildings or anything or faculty, but the brand equity, prestige, all of those sorts of things. The highest profile new college is the University of Austin that just started up. They just finished their first year with their first freshman class. So we'll see what happens there. But we do have, different policies, centers, and institutes of civics, of excellence, of great books, of all these different things, especially at flagship Southeastern and Southwestern universities. So whether it's Arizona State, UNC, University of Florida, Florida State, these schools have these institutes that are attracting more applicants. It's very interesting. There's been just in the last few years, applications have gone down to Northeastern schools and they've gone up to some of these Southern schools. So, that's a little bit of market forces. And as donations drop even a little bit, even, Harvard has a $50-60 billion endowment, but they still they notice if donations are down 5% in a given year, as they were a couple of years ago, they notice that and they try to figure out how they can stop it.
Yeah, one of the things I think you probably saw in the news too here recently, I think it was in the spring, they're saying that the 21 to 29 demographic's pretty much done. They're over they're just woke. It's too bad. But the 17 to 21s are changing. And I would say as a college baseball coach working with 17, 18, 19-year-old kids this last spring, I heard a lot from, we'd have all kinds of conversations in the bullpen. I'm a pitching coach. And there were a lot of them like, Coach, we're over it. We're over it. Screw it. We're over it. We're not doing the woke stuff anymore. Things that they grew up with in high school that they just kind of, turned their heads when they had to. I think there's a backlash, and I think you're right.
Absolutely.
Yeah, I think
absolutely.
So we have a new generation, and the argument is these kids are turning more quote unquote conservative. You're hearing that more and more, and we are at the end of another one of those 80-year cycles where they say, that the hard people turn into the soft people, and the soft people turn into hard times. And so we're at the end of we're 80 years out of the World War II era, so maybe we're going to have a next generation. These kids are going to clean things up, hopefully. Mr. Shapiro,
right. I got 4 kids under 9, so I hope they do.
You're doing your thing then. Yeah, you got a whole school full of kids there to get that stuff done. Please tell everybody again where they can find you, where your books are, and all of that. Please go through that.
Sure.
First.
So I have a Substack newsletter called Shapiro's Gavel. I work at the Manhattan Institute, whose website is just manhattan.institute. On Twitter, X, I'm at iShapiro, and my books, Supreme Disorder and Lawless, you can buy wherever you get your books, whether it's Amazon, whether it's other online retailers.
Well, Mr. Shapiro, I really enjoy having you on. This has been wonderful. It's good to see somebody out there fighting for the Constitution that's actually studying the Constitution and can articulate to people what the hell the Constitution actually says. God bless you, sir. Thanks for you being here today, and love to have you on again sometime soon.
Thank you. Have a good weekend.
Thanks for tuning in. If you like the show, subscribe and hit your notification button to get an update when we post another episode. See you soon.